And in the report, in the recommendation, they originally said that every member state must have a collective redress mechanism. It's interesting how the language and the rhetoric of the debate have changed, because when these issues started off, all the public debate was talking about class actions, and therefore American class actions. And huge arguments about, well, we need them for access to justice, or business saying, no, we don't need them because they're abusive and captured by lawyers and blackmail settlements, etc. And those two positions were logically and politically impossible to reconcile. But it was interesting that the European Commission changed terminology and started talking not about class actions, but of collective actions. In other words, meaning court-based collective litigation in a European model, and changed the terminology further to talk about collective redress. We like that terminology because we think redress is the outcome. There are situations where you need redress and you get it. So that's a technical question that does not assume the technique, does not assume the method. It says, how do we get it? And in this particular book, which will be published in 2 or 3 months' time, we pull together a great deal of empirical evidence comparing different models. We're going to go through this. In the course of this, it tells us, we think, quite a lot about redress and about regulation generally. So it goes way beyond the collective issue, but it's quite an important point. Now, in asking the questions, we basically ask two forms of questions here about saying what is the mechanism, and there are various different mechanisms. How do you deliver redress? How do you resolve disputes? But one goes further than that. And the two viewpoints are firstly purely the practical and technical ones about saying, okay, we have a particular mechanism, like court case, or mediation, or ADR, or something else. And we go into quite a number of something else. They're just mechanisms. Can they be improved? What are the architectures? So you will see things on here about outcomes, and redress is actually number 8. But the other viewpoint is to look at things from the perspective of the market, because certainly from the EU's perspective, it is an internal market, and therefore all the EU legislation is in the context of the market. Now, we ask ourselves, what would you want in relation to looking at things through the market viewpoint? And we came up with this broad list of points. And we'll come back to these at the end. If you're looking at the market, you make a rule to start with. You then want to identify when it goes wrong. You want to identify situations when maybe the substance of the rule is changing, but in particular, where people are not abiding by the rule. In other words, they're breaking the rule. How often does that happen? In what circumstances? Now, if it's illegal, you would then want to have the ability to stop that breach. So you'd think about injunction powers, or in the European context, you think about the injunction threat. You might actually want a decision on whether the conduct is in fact legal or illegal. So you want a reference to a decision maker, usually a court. Sometimes it would be a regulator, depending on the sectors. Certainly in the major regulated sectors of financial services, insurance, energy, communications, utilities, transport, regulators make a lot of decisions about what's illegal. An important point, which is frequently overlooked, is then to ask, okay, someone's broken the rule. Why? What happened? What was the cause of that? In other words, that's what scientists, and especially in the aviation industry, we call root cause analysis. So in the aviation industry, they don't say a pilot or an air traffic controller or an engineer. broke this rule. They say, why would any human in those circumstances make that mistake? So we're not going to blame the individual, as long as the individual shares the information that something's gone wrong. We actually want them to share the information, so it has to be a led-by culture. And the question that we are then able to ask is, why? What's the root cause? And the answer to that could be a whole range of things. It could be this person has been trained well enough, or it could be it's the wrong type of person doing this job, maybe psychologically involved. It could be that you need more IT, more warnings, all sorts of solutions. But you're never going to know that if you just blame the person and say, you're at fault, you've broken the law. You have to ask a deeper, root cause question. And many people involved in safety, services of aviation, but pharmaceuticals and other things, do this automatically. But it doesn't happen so often in other types of enforcement. It's absolutely critical. Once you know the root cause, you know what you can do about it to stop it happening again. How do you prevent recurrence? And then once you know the answer to that, you go to number 6, which is to apply that to the individual humans or the organisation in which they operate, or indeed every relevant organisation in a sector, like all the energy companies, so that the learning is applied widely as quickly as possible. One then gets into putting things right, so repairing the environment or paying redress to consumers who do harm, whoever it is. And you may or you may not need a sanction at the end of that. Rather interesting that the energy regulator in the UK has changed its approach in the past 5-6 years. They used to fine energy companies a lot of money. And the fines have all gone down, apart from last year, which is normally for other reasons. Whereas they used to think that redress was nothing to do with them. And now they do think it's them because they're applying this list, this sequence of thought processes. So whilst the number of fines have gone down, the redress that the energy regulator achieves has gone up from 0 to a very large number. Because they're saying to the energy companies, you've overcharged consumers, you need to pay them back. Let's do that. So the regulators have changed their mindset, and they're by no means the only example. And the reason they get down to a 0 fine is that they say, well, we've agreed the changes in behaviour. We've agreed the redress. The companies are doing that. They cooperate with us. They will usually be fined £1 if they approve that process. And that's rather different philosophy from saying a competition authority or indeed the financial regulator in the UK that similarly achieves nonsense, who still use a deterrence theory of imposing a very large fine on banks. But they're in the minority of regulators now. You then find point number 10, you need to look at what you're doing and say, okay, did we get the right theory? Did we identify the correct root cause? Have we identified the right action, the right fix? Have we put this in place? Now, this is a very different way. It's a regulatory way of looking at behaviour in marketplaces. It's very different from the classical legal analysis of saying rule, breach, sanction, everything's wonderful. Because that's not real life. And one looks at how do we make sure that we improve the number of situations where things are wonderful. And that you need to ask much more detailed questions. So we look, for example, in redress systems, therefore, at how do they score them, about not just how they do number 8, but do they do all of these? How do we identify large consumer problems? Or indeed, SMEs who've been paid late, how do we identify that? Because they may be very scared to tell us what they're being paid late, because they'd be afraid that they'd be struck off the list. That's an answer to those points. But this is a very different way of looking at the market and the structures and the intermediaries that we need in order to deliver these objectives. In this research that we've done specifically on collective redress, we therefore redefined the previous list, and we've come out with 11, about saying let's look at several different types of class actions. We call ADR generally consumer ombudsman, not in a Nordic sense, but in a more southern UK/Belgian sense. And regulators and how they work, or maybe even criminal courts and how they work. So we've looked at lots of these and we've found case studies of redress situations. And we've scored them, as we'll show you right at the end, against these criteria. Some of them are simple questions about can you access them, how long do they take, how much do they cost. But number 11 at the bottom is a very important one about saying, does it lead to change of behaviour? Does it lead to the regulatory change? And the behavioural change in market actors. I should make one point straight away that we're huge fans of the consumer ombudsman model as it is in the Nordic countries. But we're going to usually use the word ombudsman in a different sense. In the way it appears in our two countries, Belgium and the UK. So the ombudsman there are a form of alternative dispute resolution mechanism, which is quasi-regulatory, and they're complaint mechanisms. So they are equivalent of, say, your consumer complaint boards that exist here in one example. So let's make that linguistic point, and we'll come back to that later on. I'll now hand over to Stefan.
Okay, ladies and gentlemen, good afternoon. My name is Stefan Fuchs. I'm from Cameroon in Belgium, and first of all, I also want to thank organizers of this event for the very kind of invitation. Now, as Chris has just mentioned, the title of this conference is Delivering Access to Justice, and we are looking at this topic, access to justice, from the angle of mass harm situations. We're talking about different techniques, different mechanisms to resolve these mass harm situations based on the market objectives and performance indicators that Chris has just mentioned. But I want to emphasize that the conclusions we draw from that actually transcend these mass harm situations context, in the sense that we ask ourselves the question, in which way can we deliver access to justice also outside of the scope of these mass harm situations. And basically what we are going to do now in the second part of the presentation is actually going through these different techniques, going through these different mechanisms. First of all, I'm going to talk about collective actions, class actions, collective redress mechanisms as the European Commission calls it. In a second part, we will look at some of the alternatives, including regulatory redress, consumer dispute resolution, then the partie civile mechanism. And I think there are some people in the room who know something about criminal procedure. I think that would be quite interesting for them. And finally, some administrative agencies. We will go through these techniques from a theoretical perspective, but what is much more important, and that is the research that we have conducted, is we also want to give some empirical efforts. And how do these mechanisms, these techniques, score against these specific market objectives and these performance indicators? And then we will try to draw some conclusions first. First of all, collective actions, class actions, I assume that everybody knows what class actions are, representative actions where one entity a person, can be an association, a foundation, whatever, brings a case in court on behalf of a large group of people who are confronted with the same or similar legal and or factual issues. This leads to a court decision that is binding for all of these group members, unless they have not opted in, or unless they have not opted out. Now, when you take a step back and look at the collective redress debate, the class action debate, there's a very interesting development. As you all know, class actions basically are originated in the US, where they were changed in the 60s, and that system was basically developed into a very powerful tool, in the sense that now damages class actions can be brought, and these cases are being brought on quite a regular basis. But when you look at the evolution of the last couple of years, then you see that in the US, the class action doors, as they are called, are closing gradually, in the sense that the last couple of years there have been a number of Supreme Court decisions making it difficult to bring in federal courts, not state courts, but making in federal courts to bring these class actions. And the debate on the federal level in the US is that you have this rise of also alternatives. One of the alternatives is what's called the NDL procedure, or the district litigation procedure, or the rise of public-private compensation schemes. For example, after the BP oil spill, one of these schemes was set up. Also after 9/11, one of these schemes was set up. So that is what is going on the other side of the Atlantic. When you look at Europe, gradually, the last 10, 15 years, there has been a growing interest in class actions and collective redress mechanisms. Tom Hartly, the famous Dutch scholar, wrote in 2007, it is clear that resolving mass cases must be prioritized and that possible obstacles in the law must be cleared out, even when they have their foundation. Principles, it is clear that there is dynamism in this part of the law. And then, consequently, the last 10 to 15 years, the European policymakers have issued a number of studies, white papers, green papers, consultation papers, etc., basically thinking about that issue, thinking about collective redress mechanisms, thinking about this class action mechanisms. I will not go into detail, I would like to mention the first one, not because it was drafted by the policy, but because it's an important one still to date, in the sense that in that Leuven report for alternative means of consumer redress, and it basically overlaps a bit with what we are talking about today, it gives an overview of all the mechanisms, the tools that one can use to offer consumer redress, / to offer to obtain access to justice. And it contains, it contains what's called a dispute resolution continuum. I very much like that word. And here you can basically see that dispute resolution continuum. And basically that is the angle that Chris and I are using to look at that problem. You see, court actions, collective actions, for damages are just one specific aspect, one specific mechanism, tool in that dispute resolution continuum. And I think it's something, I mean, if people want to do research on that, and if you want to look at that from a broader perspective, I think that dispute resolution still is very important and can be useful. Now, we will come back to some of these issues, but again, in this first part, I will focus mainly on actions for injunctive and collective actions for damages. As you know, in 2013, the European Commission issued a recommendation which is a non-binding instrument. And in that recommendation, the European Commission basically says two things. First of all, it says that member states should have these collective redress mechanisms. And secondly, it lists a series of principles regarding the judicial and the out-of-court resolution of mass harm situations. And basically, the whole concept of that recommendation, the whole policy context, is based, and I will come back to that in a second, about creating safe governments. Because the two basic goals of that recommendation is, on the one hand, offering access to justice for consumers in case of small claims, but on the other hand, to avoid abusive, frivolous litigation, as we have seen and some empirical studies have shown in the US. And it has to do basically with, I think, the most important issue has to do with the question of who can bring these cases. I will come back to that in a moment. So that recommendation focuses on collective redress. On the one hand, injunctive collective redress. As you are aware, there is also another instrument that deals with injunctive redress, that's the injunctions mechanism. I want to mention that because it's important for our story. And secondly, and that's the most controversial aspect, the most controversial part, is compensatory collective redress mechanisms. So when you have an entity, a person, bringing an action in courts and claiming damages, claiming compensation on behalf of a group of individuals who are not involved in the procedure, but who are bound, to use the civil procedure term, who are bound by the res judicata effect of that decision. And that recommendation, as I mentioned before, lists a series of principles. And you can see them on the slide. First of all, the recommendation makes a plea for what are called transubstantive or universal collective redress mechanisms. And it said that the European Commission says there should be these mechanisms in all fields of law where the European policymaker can issue decisions, can issue a specific policy. The most important one has to do with consumer protection. And as Chris has just mentioned, last week, the 25th of January, the European Commission, on one of my previous evaluation in 1780. Last week, on the 25th of January, the European Commission published its report. It's not a very exciting document to us, in the sense that it just says a lot of things that we already know and most people know, but it contains, in some paragraphs, you can see a change in policy, but we will come back to that in a moment. And in that report, for example, it's made very clear that most of the countries, the European countries, that have these collective redress mechanisms focus on consumer protection. But also in some other countries, and I will come back to that in a second, there's also attention, the focus is also on competition. Two, injunctive and compensatory redress. Three, and that's an important issue, in the sense that in the US, class actions are usually being brought by individuals, by people who have suffered damages. Class actions can only be brought by somebody who is a member of the class, who is a member of the group. Now, this has led in the US to abuses, in the sense that these cases are usually being brought by lawyers, and the class members, who are the class representatives, are nothing more than what some lawyers call a key to the courtroom. So these procedures are basically largely lawyer-driven. The European policymaker has taken a different approach and basically adheres to the principle that standing should be given to associational or organizational claims. Now, one would think, well, that would resolve the problem, but our research has shown that that is not true. It can also lead to conflicts of interests, hence it can lead to no or less redress for consumers. But the bottom line is that you should have an outsider, not somebody who has suffered damages, who can bring these cases. And basically, these are associational or organizational plaintiffs, consumer associations, minority shareholder associations, or in some countries, and we will also come back to that, public bodies. For example, the case that probably know in Denmark, but also in Belgium, we have a consumer mediation center, a consumer mediation service, which is a sort of public body that can bring consumer class actions. But we will come back to that. There should be a certification phase, so a phase regarding the admissibility of countries in their collective redress laws have a number of certification criteria, and if the certification criteria are met, then the court issues a certification decision. Lose-based rule is a very important principle because the main problem, and also we will come back to that in a second, is you can develop, from a procedural point of view, you can develop a very interesting and good collective redress mechanism. But at the end of the day, somebody will have to pay for that. There's no such thing as a free lunch, so somebody will have to pay for that mechanism. And that is one of the most difficult problems that we see in a lot of these countries where they have these redress mechanisms. This is also because of the lose-based rule, no contingency fees, although the recommendation leaves it open, the recommendation says you can have contingency fees as long as this is regulated. The report of last week basically says that there's no country where you have contingency fees. With one exception, I think, is not surprisingly Lithuania. Lithuania apparently have contingency fees. And there will be some experimentation with contingency fees also in Slovenia. No punitive damages. Third-party litigation funding, I think we can have a conference on third-party litigation funding, but basically it also says it's kind of skeptical, but at least it should be regulated. The default, according to the recommendation, is that these mechanisms should be an opt-in mechanism, because opt-in is compatible with Article 6 of the European Convention of Human Rights. Class members should deliberately come forward, step into the procedure, and basically declare that they will be bound by the resident task effect of this. They do not become parties to the procedure. They don't emphasize it. They just say that we will be bound by the resident task effect. Although, on the other hand, some systems now also have opt-out mechanisms, in the sense that when you meet the class description, if you are a member of the class, as described by the court in the certification decision, then you are also bound by the resident task, unless you say, I'm out, I do not want to be bound by the effect of that decision. So that is basically an overview of the building blocks that you can find in the recommendation. So on the one hand, it says access to justice, especially for small consumer cases. But on the other hand, you have this list, and here you can see it on a different slide. You have this list of safeguards, because there is a fear that the mechanism will be abused for frivolous, abusive litigation. Now, the consequence of that, and our empirical research has shown that for a large part, is that you have in a lot of countries these collective redress mechanisms, but you have this enormous list of safeguards, which creates a catch-22 problem, in the sense that you have too many safeguards, that the mechanism is not being used because there are too many safeguards. You stand alone instead of follow-on. I will come back to that in a second. Opt-in instead of opt-out. The recommendation allows you opt-out. Most countries still have opt-in. Restriction of standing to certified personnel, independent governance, certification by the court, and you can read that also in the report of the European Commission. In a lot of countries that have certification phase, but it takes a lot of time, it takes a lot of money, it sometimes takes months or more than a year before the court issues a certification decision. Then these decisions should be notified to class members in order for class members to take a decision regarding opt-in, opt-out. The certification criteria itself are also sometimes, as the report shows, a hurdle. And then the basic problem of the most important problems is the funding and the financing of these issues, user fees, no contingencies, etc. So all of these safeguards do have their function in order to avoid certain abuses, but the consequence of these safeguards is basically that they kill the animal. It's a catch-22 situation. Now, regarding some of the controversial issues that you can find in the recommendation, is first of all, has to do with the scope And the recommendation, as I mentioned before, states that member states should have collective redress mechanisms in all areas where union law grants rights to citizens and companies, but as the report shows, the same consumer protection. Regarding antitrust, competition, and data protection, there are different instruments. 2014 was a directive on antitrust damages actions, which does not contain a class action, but basically makes it easier for people who have suffered damages as a consequence of an antitrust breach to bring these cases. For example, there are rules on prescription, there are rules that one can use the decision of the National Competition Authority in the civil case to claim damages. Another set of rules you could find in the General Data Protection Regulation and the directive. Now, in some countries, for example in Belgium, this was controversial. Because in Belgium, we have a class action mechanism that can only be used for consumer law cases. Now, some scholars said, well, that's a discrimination. It's a violation of our constitution in the sense that you have collective access to justice for consumer law cases, but for cases falling outside of the scope of the law, competition law, environmental law, there's no collective access to justice, there's only individual access. So that is a discrimination and violates the non-discrimination principle in the Constitution. Constitutional Court said, well, no, that's not the case. It says that most of these class action cases or most of these class right situations are consumer cases and it's just for testers. So there's no discrimination. But that's an issue. Also in France, there was an issue. In France, we'll talk about that later. They have a class action mechanism, but in the beginning it was only for consumer, and the Conseil Constitutionnel in France also said that that's not a problem. Now, it is important to see that background because at the bottom, you can see, and we will probably talk about that in a second, is, as I told you before, the recommendation is being evaluated, there is the report, and probably in April, the European Commission will come up with a proposal on what is next. Now, the competent commissioner for consumer affairs is Ruofa gave a speech, and there she said that one of the plans that they are thinking about, one of the possibilities that could happen is that they could amend the injunctions directive. Whether it is a good question is something else. Again, we'll come back to that. So the injunctions directive allows for qualified entities who meet certain criteria to bring injunctions against a company that violates the law. What they basically want to do is maintain that framework, but add another layer and allow these qualified entities not only to bring injunctions, but also to bring corrective actions. Again, whether that is a good question in light of the outcome of what we have come up with, that's something else. So where do you have these transactions? You can see a number of countries. In some other countries, they're not really class actions in the sense that they're representative actions, but group proceedings. It is important, and I think that's something that was underestimated, I think, by the European policy makers, in the sense that each national model is completely different and is embedded in a completely different legal culture. And these mechanisms, they function differently. And in some countries, in some jurisdictions, as again we will show in a second, other mechanisms exist that can achieve the outcomes much quicker, much better. One aspect that is important in this setting has to do with the relation public-private enforcement. Now, that division is basically fading away. Walter van Gijven, who was an emeritus at the University of Leuven and was Advocate General at the European Court of Justice, passed away last year, once wrote a fantastic book about the blurring division between public law and private law. He basically said that public law has been privatized and private law has become public. And that's important in this context, especially when Chris will talk about public enforcement, we'll talk about regulation, we'll talk about regulatory redress. If you look at the recommendation, there is still a very strict juxtaposition between public enforcement and private enforcement. And that has to do with what is called in class action theory, one of the goals of class actions. Traditional goals of class actions is access to justice, procedural economy, procedural efficiency, and the third goal is deterrence. But the question whether that works, I think Chris will answer that in a second, is making sure that other companies from the same sector don't violate the law. That is the question about deterrence. Now, the European policymakers, especially also in the recommendation, have said if we will have these collective redress mechanisms, they should serve only the first two goals of access to justice and procedural efficiency, but not the deterrence goal. There is said that you cannot bring these collective redress cases in the context of public enforcement. And an example of that you can find in some countries that have collective redress mechanisms in competition. For example, in France, you can bring a class action in competition law, but you can only bring these cases, these judicial private cases, after the public process has finished. So you can only bring them when a national competition authority has finished its investigation. And then with that decision in your hand, you can bring a private class action. So only for reasons of procedural economy, efficiency, access to justice. Second one, and that is also emphasized in the report, but we think that there are better mechanisms to achieve that, is that the European legislators, European policymakers say, well, members, you can have these collective redress mechanisms, but basically what we want is that we settle these cases out of the court without going to a court. And some systems are completely built on that theory. The best example, and it has become an export project, one of our friends and colleagues, Suleiman Kamboum, wrote a wonderful paper a couple of years ago about the Dutch Collective Settlement Act, and the title of that paper was Beyond Tulips and Cheese. And he says, you have tulips and cheese in the Netherlands, now we have the Dutch Collective Settlement Act that we can use all over the world. And that Dutch Collective Settlement Act is basically a settlement-only class action. And what they did is they looked at the US, and in the US, most of the class actions are settled after the certification decision. They don't have a decision on the merits of the case because then they have juries, they have discovery, way too complicated. So in 90% of the cases, these cases are settled. And the Dutch said, well, that's fine. Let's copy that class action mechanism, but only the settlement aspect. And now we have that settlement, the Dutch Collective Settlement Act. And it basically boils down to this. There's a mass harm situation. You have an association or a foundation that is being created for the purpose of defending the interests of the people who are suffered by that mass harm situation. The association or the foundation starts negotiations with the company. They come up with a collective settlement, and then they go hand in hand to the court and ask them and ask, please homologate, approve this settlement. It has been said that this model is very successful. I'm a little bit more skeptical in the sense that since 2005, 9 cases have been brought under the Dutch Collective Settlement Act, and they are all student cases. They're all consumer cases. But then I think it's a bit difficult when you say that this mechanism wants to enhance consumer redress, that in most of these cases, these are investors, shareholders, that will have some damages. But you could also find it in the recommendation. Belgium is the same. Belgium has a class action, consumer class action, and once the class action has been certified by the court, then there is a mandatory negotiation. So the second aspect is the out-of-court aspect. Standing, I talked about that, so the focus is on consumer associations, minority shareholder associations, or special purpose foundations or ad hoc associations. But also, and that is important for our story, in the sense that in some countries, and there it seems to work, as our evidence shows, sometimes public authorities could bring these private class actions, which is, for example, the case in Denmark, Now, the consumer ombudsman in Denmark is not an ombudsman as essential as the is basically the regulated, the competent authority, and he's the one is the only person who can bring opt-out class action. Now, the Danish consumer ombudsman never has to bring that opt-out class action because she has other mechanisms to resolve these mass harm situations. And the previous consumer ombudsman, who's now an advocate general of the European Court, used to call his opt-out class action possibility his nuclear bomb. That was the term that. Belgium is the same. Belgium implemented the ADR directive in 2014. We needed to have consumer ADR in all sectors. How did we do that? We established a residual ADR entity, which is called the Consumer Mediation Service. That Consumer Mediation Service, which is a public body, also has a standard to bring a consumer transaction. Opt-in, opt-out, again, the recommendation adheres to the principle of opt-in. It's the system that you could find in most European countries. Opt-out is also allowed by the recommendation if this is what is called not justified by reasons for sound administration of justice. I have no idea what the reasons are. And in some countries, you have that. For example, in Belgium, I think also in Scandinavian countries, where the court can basically choose between opt-in and opt-out system. Also in the UK and in the Netherlands, some of the Dutch courts. And the final point, and that's already what I have mentioned, is the funding and the financing issue, which is, I personally think, a very difficult bottleneck to bring these cases. And if you allow some of these rules, for example, contingencies, third-party litigation funding, then this can lead to the situation where the representative or the lawyer of the representative or the entity that is funding the representative can have a personal interest in the outcome of the litigation. Now, as long as you have enough safeguards, you would say that is okay, but in the end, and the question remains whether in the interest of consumers and whether in the interest of bringing redress to consumers, that is the best way to do. And the question we have asked ourselves, maybe there are other mechanisms that avoid these problems and that do deliver redress in a much more efficient manner. Give the floor back to Krista.
So, we have these core-based collective mechanisms. There's a problem, there's a conundrum. If you don't allow safeguards, you may get an enormous amount of abuse. If you do allow safeguards, they don't work. That's a classic catch-22. What else is there? We'll now run through the other major alternatives. And we've called one regulatory redress because it is redress that is brought about by public bodies, enforcement bodies. There's then various different questions about consumer ADR, or particularly ombudsman in the non-ombudsman sense. Logically speaking, we might talk about partisanship first, but we'll leave that later. And then there's a specific context of looking at personal injuries and looking at injury schemes. Now, I should immediately say that you'll notice throughout this section that actually Nordic countries, if you like, score well. So we'll draw out some conclusions from that. And we're as I said, very attracted to a number of the Nordic solutions here. So the first issue is regulatory redress. Savannah just referred to Martin Karen, who is looking at the difference between public law and private law, etc. It's multi-layered framework. This draws on what I was talking about at the beginning, about a number of regulators in different countries. Thinking quite deeply about what it is they're trying to do. They're not just trying to regulate markets or prices. which economic regulators were originally intended to do, say 30 years ago. And we now got structures throughout the EU, public regulatory bodies dealing with financial services, energy, communications, utilities, transport, post, pharmaceuticals, medical devices, etc., etc. And in some countries, like yours, you've got a broad consumer authority and individual consumer rights. Quite a lot of these regulated authorities exist within ministries, especially in the smaller countries. And they haven't necessarily thought, rather than standalone authorities, they haven't necessarily thought about what it is they're trying to do. So they're still thinking about markets and prices, but some of them have really evolved into much. A quick example of the UK energy regulator, Ofgem, earlier on. Of course, it's thinking about markets and prices, but in thinking about markets, it said, well, the market consists of two types of people who buy energy, businesses and consumers. What outcomes do they get? You can't think about the market. What outcomes do these people get? Are they happy? For example, are consumers happy? And are there lots of overpricings, or are there lots of breaches of consumer law that we should address? Because otherwise the market isn't going to work, and people are not talking about buying to markets, about switching, etc. But therefore, the regulators are thinking about, we have to look at consumer issues in order to control the market. So that takes them into that list of functions that I was talking about earlier, within which some of them have started to think about redress because they're automatically part of what they need to do. And what we've discovered is that there are some regulators in some countries, when they are given a redress power, or even when they're not, they can simply turn around and say to the entities, fine, pay everyone back because we've got the power to take you to court on an opt-out mass basis. But we don't need to do that, do we? Because you're going to agree to pay redress. And in many issues of overcharging, sometimes involving banks or insurance companies, but certainly in relation to energy or transport or communications, it's very easy to pay people back because you just recreate the next bill. It's almost like a switch. There are some circumstances where it's more complicated, and that raises the question of what mechanisms we have if we want to avoid the complications going off into court mechanisms. I first discovered this in Denmark, where we noticed that the national class action procedure gave an opt-out power only to the consumer. And we started talking to Eric quite a few years ago, and he said, well, I use it every day, but I use it never, because that says you've never taken anyone to court, because he's threatening to use it as part of the discussion about you've broken the rule. What's the fix? And by the way, it's going to be redressed. And what about sanction? Let's move on. So it's a toolbox issue. One point within the toolbox, and it's an integrated debate. And he said it's very easy. These discussions don't take long. There are incentives on the companies to agree things very quickly, which they usually do. But he's the only person in Denmark who has an opt-out power, because he's trusted. He's a public official. You don't give an opt-out power to a lot of lawyers because they've got their own personal financial incentives behind that. Give it to an independent, trusted public official. Now, what I then discovered was actually in the UK, the financial authority had got a similar power going back to 2000, and they had used it, but not very much, and they hadn't told anyone. So having discovered that, I had a long talk with them, and they said, yeah, we use it quite a bit, and they've done the same thing quite regularly. And then that spread to the energy and the water, the regulator, etc. And now every public enforcement official has got this regulatory power. But in the Consumer Rights Act, which is a broad generic piece of legislation, But it's rather interesting in Consumer Rights Act because of the clues. You can agree with a regulator can agree with a company behavioural issues. In other words, what do we do to fix things and fix behaviour if something's going wrong, as well as redress it. So the toolbox has been expanded. Same point, where these powers exist, everything is usually agreed. Very rarely goes to court, unless it's perhaps to be approved in some situations. But it's very quick. And that started ringing a big bell when we were thinking about alternatives. Now, we've had various conversations with other people, so almost by accident, when I was talking to the Central Bank of Ireland or the Bank of Italy, Central Bank in Italy, saying, have you ever used these redress powers? And they said, yes. And I said, well, why doesn't anyone know about it? And they said, well, we've not really told anyone. But you find it all over. And not so long ago, I thought, well, maybe you don't need a redress power if you've got a regulatory system within which the regulator has a license, because that's an ultimate deterrent. It's a nuclear bomb because you can threaten to take away a license, or you can amend the terms of the license of the system. So I got in touch with a friend who's in the Italian energy regulator and said, "Do you ever use mass redress?" And he said, yes, and these are examples. So actually it's quite widespread, but it's not very well known. You do, of course, need safeguards in that system. Final point on this slide. So there are a lot of negotiated solutions. You do need safeguards, but they're usually easier safeguards for officials because you've got transparency, governance issues that can be put in place. Now, why do they do all this? This is a much broader question, and we haven't really got time to go into this. And it's a rather different question, but because of some people in the audience who might be interested. About 5 or 6 years ago, I started to ask questions about what public enforcement is and what works. And that's this very large book on the left, which is 800 pages and really very tedious, but it's got a huge amount of information in it. And there are several strands of information, so to just give you a broad overview. One strand says most regulators or enforcers ask the question, how do we increase deterrence? That's the wrong question. The question is, how do we affect future behaviour? If you impose a penalty, that is always backward looking in relation to just desserts theory or proportionality. We assume, under some theories, that that is going to affect future behaviour. What is the empirical evidence that it does affect future behaviour? In other words, this answers a pretty fundamental question about does the deterrence work? Now, in that book, I pulled together a lot of American studies on private enforcement generally, which includes concepts of private enforcement. And also, I looked at other studies on public enforcement by, say, a competition authority, especially the European Commission. And the bottom line of the studies that I looked at in those two areas says that actually there's very little evidence that deterrence affects future behaviour. Of course, one is well aware that in the traditional philosophical tradition of legal thought, going back to the Greeks, individual responsibility thinks about deterrence and just desserts. Similarly, in the separate line of thought of mid-20th century Chicago-inspired economic theory involving rational actor theories, deterrence is absolutely central. So if you ask any economist or competition regulator, how do you affect future behaviour? They think you impose it at a fine. And there are two principles within competition thinking or economic thinking about you will increase deterrence if you increase the fine and you increase the the incidence of people being fined. Now, that's economic theory about rationality. You then look at another stream which says, how do people behave? Not theoretically, but how do people behave? How do people make decisions? And therefore, how can you affect issues? And that takes you into behavioral psychology with a bit of evolutionary biology. So, one starts to read things like Kahneman, thinking fast and slow, or Felix, just to give you the Nobel Prize for a very similar approach for nudge theory. So it's known as nudge theory or behavioral economics, but actually it's behavioral science in its own right. And most of that undermines most of the theoretical thinking within the theories of rationalities. That's a proposition with which you might agree or not agree, but that was my conclusion, and there are quite a few economists who think that. Not all. But if it's true, you're then thrown back to the difficult question, if you're a regulator, of saying how you affect future behaviour. And the answer is not by deterrence. So, for example, the behavioural psychology says that in most situations, increasing the penalty doesn't have much effect. People have got to think about it and be reminded about it and make a decision. Shall I speed? Well, if you're going to say, if you are caught speeding, we'll kill you. But if you're caught speeding and the fine is 10, 20, 30, 50, even 500 euros, you might not think about it when you do. And the psychologists say that the really important question is what's the perception of being identified? And it's not the economic theory of what's the risk of being identified, it's what's the perception of the individual of the risk of being identified. So you can affect people by affecting perceptions. And indeed, in many ways, that is behind a lot of the US legal system, with everyone suing everyone else, or everyone trying to attack everyone else for doing something wrong. Not terribly easy society. Well, we've had societies like that, like say Stalinism, etc., and they're not very attractive at all, because everyone's trying to criticise everyone else rather than be cohesively work together. So that takes you into other questions. The next strand of thinking here, we're looking at what's known as responsive regulation. Quite a lot of empirical regulatory enforcement work, of which John Braithwaite of the Australian University of Canberra is probably the leading figure. But a number of people have done studies on this, including Keith Hawkins, who's my associate studies 40 years ago. A lot of people at LSE looked at railways or mining or fishing or lots of things. And that went around and asked a lot of enforcers and regulators, what do you do? And basically the answer comes back, well, we don't prosecute people or deter them very often because it doesn't work. And it usually destroys the relationship if it's an ongoing relationship. And makes people less likely to observe the rules. Usually what we do is go around and say, would you mind buying a new pump now, not next year? So it's a relationship, it's engagement, it's trying to affect the root causes and the fixes. We've got a lot of chemicals that's reaching into the ground, or sewage going into the river. Well, what's the answer? Get the plant fixed by a new pump, whatever it is. It could be much more sophisticated. But it's actually engagement. Now, what I then found was how many UK regulators were doing that. Around about 2010, all of the UK regulators were required to issue a written enforcement policy. And I think we might be the only country that's done that. Another large part of that is going rather tediously through a lot of those enforcement policies. And what you find is that very few of them use the context of deterrence, even the word. within what they're thinking about when they enforce. Large numbers of them go around saying, well, we try to help people do the right thing in a holistic way, not just breaking a rule. It's actually having a good system or a good culture that they're doing the right thing, and therefore the risk of things going wrong is going to be lower. Interestingly, the economic regulators all started off using deterrence as a concept, say 20 years ago, and they've all moved, or most of them, moved into the let's work with businesses to do the right thing sector. And it's quite a collaborative approach. It doesn't mean to say that you stop using hard enforcement sanctions. Certainly, you've got serious criminals to do with internet pornography or money laundering, etc. That's fine, but you see that if you, like the energy example I quoted, if you're dealing with sensible companies, you've got the power to talk about business, and you say you could do that tomorrow, but wouldn't you actually like to put in place a transitional program within which you will improve over time? When you talk to, say, the chief drinking water inspector, he's working with quite a few companies now who've got it, but it may take 10 years for them actually to improve what they do. Expect things to go wrong in the early years. And if they do, he might give them an enforcement notice and put it right immediately, but he might not prosecute them. And if you were to prosecute them, they'd get demoralised and would stop improving. And because he says, okay, but keep going, they're energised and they keep going to improve. I've had so many examples like that. Now, what this boiled down to was the concept of saying, let's all work together to do the right thing. And that became christened as ethical business practice and ethical business regulation. You'll see in the middle a policy paper that the Department of Business UK asked me to write, which was a 10-page version of the 800-page book. And we've just written a readable paperback, which is a mere 300 pages, including not a lot of endnotes, which is this one. Which includes at the end, written by Ruth Simons, approaches to how businesses can be ethical and really create an ethical culture. And there are various pilot studies that are now going on with restaurants or Scottish Water or data protection commissioners, even university regulators, and so on, certainly food authorities, about trying to put this model into practice. Fairly early days in taking the model forward, but it's looking incredibly exciting. But in that context, redress just happens. One of the things in the middle. So, next technique. ADR. Okay, ADR. ADR is wonderful because it short circuit things, people get together and sort them out. But what is, of course, people do that? Well, you can have mediation, you can have arbitration, conciliation if you think that's different from mediation. But the architecture can be either connected or not. You can also have online dispute resolution, and the Commission has an online platform at the moment for cross-border consumer claims. Very few traders pick it up, so it's not been a success at the moment because it's not a requirement for traders to agree this. There's a specific technique within ADR, a specific architecture that works. So we talk about consumer dispute resolution because it has a particular architecture. And it's its own thing. And around about 2009, someone of us said, what is consumer ADR? And we went for 2 years around 10 European countries and wrote a book, I'll show you in a minute, that said this is the mapping what consumer ADR is. Now in that context, the Nordic model of consumer dispute resolution boards is clearly one of the best models. Forgive me being slightly rude at this point. It was certainly very, very good in advance of most countries when it was introduced 40 or so years ago. I now think it's a bit out of date. Sorry, but it's still good. The Netherlands has also got a very interesting and unique ADR model with fiscal policy, quite difficult to replicate. ADR in many countries is really not evolved as consumer resolution at all. But the interesting model is the ombudsman model, not in the Nordic policy sense. And what's happened here is that a financial ombudsman or an energy ombudsman or a telecom ombudsman has appeared in some countries, in some sectors. The ombudsman does a number of functions, which is why they're probably the state of the art at the moment. Going back to the first list, they can give consumers advice, so consumers can go there and say, we've got a problem, what do you think? And they'll get advice. In the UK, the financial ombudsman is contacted by 1.5 million consumers every year. We have a specific financial problem. And they say, what do you think? And that boils down into currently about 300,000 consumer cases against primarily just 4 banks. But the ombudsman cleverly puts together the information. So you've got information advice or triage, is this a problem? You get a dispute resolution package, but the ombudsman, if you go there, can aggregate all the information and feed it back. So the ombudsman is part of the regulatory system. The ombudsman and the behavioural system, because the ombudsman can turn around to the banks and say, you've got an awful lot of complaints about this problem. What's the root cause? Fix it. Now, the ombudsman would also tell the public, tell the banks, and tell the regulator. So the regulator could also say, you've got too many complaints about this problem, fix it. And actually, the ombudsman can get there more quickly and can be very effective. If that doesn't work, obviously the regulator follows up the conversation because the regulator has the powers to require the banks to do it. So that is what's happening, certainly in the UK, all the time nowadays. So it's capture of data and aggregation of data, feedback, and working with banks to change things. So this test between regulators and ombudsman, this ticks an awful lot of boxes on the initial market list. Looking at different models nationally, that's, if you like, the Nordic model with a general consumer board and then some in specific sectors. I should say that in Germany and the UK, you haven't got a triangular bit on top. You've got an awful lot of individual ones, and they're not joined up as joined them up. Because it's got, as Stefan's already said, a single consumer mediation service, which is actually 6 ombudsmen working in the same building on different sectors. And they're beginning to work together and look at aggregation of data. They've got a very good national website, so consumers are going there for advice. If they've got a problem, they don't get sorted out by the relevant sectional ombudsman. But the data is being collected because you go to a central place, and the UK is probably going to do a very similar or a private sector model in order to replicate that. The objective behind this has gone way beyond consumer resolution. It's into advice and prevention, but it's into data collection and therefore feedback and changing behaviour. More functions. That's the ADR platform. That's the book we talked about, in which there's lots of details. We're planning to do a second volume in more countries this year. So the ideal situation is where you've got an ombudsman and a regulator working together. The ombudsman will identify from the complaints or the calls that there's an issue, whether it's a breach of law or not a breach of law. And it might be we've got a new trend, a new problem. So someone needs to make a law, maybe the regulator needs to make a new law, or talk to banks about what they're doing. But you identify that. The ombudsman feeds this information back. You then get reactions from the various traders, consumers, competitors, media, regulators, etc. The regulators have got power to do big things, but things happen very quickly. So that's that sort of model. Are there any questions? Because we thought we might have a very quick break here before going on with speeches. Okay, well you get a change because it's Stefan, mate. That's one of the
Now, very quickly, so we talked about judicial mechanisms, so press mechanisms. Before we talked about regulatory press, we talked about consumer dispute resolution. But this is the fourth technique, and this is kind of out of the box in the sense that when you're asking yourself the question, you have these mass harm situations. How are they resolved in different countries? But when I looked at my own country, then I found out, and it struck me that a lot of these cases go through criminal courts. In the sense that there's a company or individuals that did something wrong. There's an investigation by a regulator that sometimes hands over the investigation of the prosecutor. There have been complaints with the public prosecutor, or the prosecutor does an investigation and inquiry, and then sues the company, sues the individuals before a criminal court. Now, I know about Finland, but in Belgium and in France, we have what is called the partie civile mechanism. The partie civile mechanism, that mechanism, basically boils down to this. You have a situation where you have a company, but the individuals who are being prosecuted before a criminal court, and you have a large group of people who have suffered damages because of that breach of law. This can be consumers, this can be shareholders, this can be companies, whatever. In our system, and it goes back to the Olympic Code, I think, of 1806, that was criminal professor years probably be better than I think. It goes back to that code, and it allows for civil claimants, people who have suffered damages, to bring their civil claim before the criminal court. Now, it exists in other countries too. I think in Germany it's called Adhäsionsverfahren, something like that. But in Germany, and for example in the Netherlands, the criminal judge can say, go away. I'm not going to deal with that, way too complicated. I'll fix the criminal aspect. But if you want to claim damages, you should go to civil court. Based on the Belgian system and the French system, the criminal judge cannot do that. It's impossible. So if the criminal judge in Belgium has convicted the defendant, has convicted the company and the individuals, then the criminal court has to deal with this bulk of civil claims, which is also a mass harm situation. Now, this has led to a technique, or the technique has been amended in a very creative way by some Belgian courts, which is very interesting. The picture, because these are not very nice pictures, as you see. It's a gas explosion. It occurred in Belgium, in 2010, in Guillaume, it's in the southern part of Berlin, the French-speaking part. It was a site where there was some construction going on, and there were some excavators, and one of these machines, by accident, hit a gas pipeline, which was not closed. So the whole thing exploded. There was a highway next to the site, so there was a huge fireball with 20 people got killed, 600 people got injured, a lot of physical damages, moral damages, economic loss, whatever. The company and the company that was doing the excavation works were prosecuted for a criminal court. In the first instance, they were acquitted, but before the Court of Appeal, they were convicted. So that Court of Appeal of Mons had to deal with about 600 civil cases. Now, what the court did was I think the judge probably had studied in the US. And in the US, you have the Federal Rules of Civil Procedure, and Rule 50 of the Federal Rules of Civil Procedure allows the federal court to appoint a special master. So what he did was basically, he said, I'm not going to deal with these 6 months. Way too much work. But on the other hand, I have to deal with it. I cannot get rid of it. So what he is, he appointed 2 special masters. He appointed a law professor, and he appointed a professor of medicine. And those 2 had to steer the committee of other experts. And within a time frame, I think of about 1 year, 1.5 years, they were able to resolve these 600 civil claims out of court. And they were actually sort of acting on behalf of the judge. Every time when there was an issue of the law, they would go back to the judge, and the judge would say, well, this is the solution, and then they could go ahead with the settlement negotiation process. I was part of the working group in Belgium, and we have now laid down best practice in the judicial code. An act on coordinating expert, experts. I don't think it was necessary to change the law, but this, ladies and gentlemen, is a very beautiful example of where you have these different techniques who can work together. The partie civile mechanism as such is not ideal, but now in Belgium we have this statutory framework that basically allows a very swift and efficient resolution. On the one hand, you still have criminal judgment because you have criminal conviction, and therefore you need a criminal court. But on the other hand, you can have the judge sending cases out of the courthouse to be able to resolve this issue. I think that's interesting. The second aspect that I want to mention about that partie civile mechanism is, I talked about France. In France, they now have consumer transactions. And these consumer transactions are being brought by consumer associations. What I have found out, and there's also somebody who was involved in our research, has found out a couple of weeks ago, there was a decision by the Tribunal de Grande Instance in Paris, which was a case against a bank. It was brought by a consumer association against BNP Paribas about financial products. But also in that case, what happened was, first of all, it was a criminal case. BNP Paribas was prosecuted by the prosecutor, and they had to pay some money back to civil claimants who had brought their civil claim before a criminal judge. There were not a lot of people who did that, but then based on that criminal conviction, the consumer association brought a class action, which ultimately failed. Very strange reasons that I still don't get. But that technique, as you see in some countries, I think it also exists in Italy, but in most other countries, most criminal judges, criminal courts will say go away. But I think that is what, it's not an ideal technique. At the end, prisons show that the scoring doesn't score very high, but it's a technique that we have found out that if you amend it into the technique, it also offer efficient and effective solutions.
One can also ask, what is the ADR equivalent in relation to personal injuries? So you can have consumer ADR issues, but there are personal injury issues. For example, in the Belgian case legislation, you have to create a panel of a lawyer and a medic who then have to create other things. Well, what if they existed already? It would be much more efficient. So, a few years ago, someone set out to say, what have we got in that area? And one starts off as tort lawyers with the New Zealand Accident Compensation Scheme and no fault scheme. But you quickly move towards the Swedish, Danish, Finnish, Norwegian schemes in relation to patients, drugs, workplace injuries and road traffic, which are all, in my view, wonderful. broadly speaking. You also find an awful lot of others. So there is a standing medical scheme in France called ONIA, which works quite well. It was copied in Poland, but they didn't copy it terribly well, so it doesn't work there very well. You find other strange things in other countries. You certainly find vaccine compensation schemes in just about every country. And you can find a lot of ad hoc schemes and others. Now, we again mapped all of these and looked at them, and you find them all over the world, basically, including some in America in relation to one or two states that introduced road traffic ad hoc schemes, insurance. One of those. 2 points about them. Structurally, they're very similar to the consumer ombudsman type thing, which gives you advice and triage to start off with. There's an investigation phase, which is more inquisitive, if you like, not inquisitorial, but it's an investigation phase. Definitely not adversarial. So you save a lot of money and people don't start fighting each other. And then you get to the support stroke payment stage. Now, a tort lawyer, liability lawyer, would say these are no fault. In fact, it's better to call them no blame for 2 reasons. Firstly, and the Nordic patient scheme is a very good example of this. What you're trying to affect is the culture within hospitals and the culture of doctors and nurses, etc. To have a no blame arrangement because you get the data. I haven't got this slide here, but one example we found from the Swedish patient information, Swedish patient compensation scheme. All the data came in, and they were looking in particular at brain damaged babies. Relatively small number of cases, but a huge amount of money for obvious reasons. Because of the information that came in on a no-blame basis, in exactly the same way as happens in civil aviation safety, they were able to say, well, look, this is why these cases have happened, and therefore these are the root causes, and these are the things we should tell the obstetricians and the midwives. So they were then retrained, to show they've been retrained. And there's a wonderful graph which showed the incidence of brain damaged babies in Sweden goes like this, and then they were retrained, and they go like that. So, because of the no blame situation about capturing information. Now I know that they've shared the same techniques amongst all the patient schemes in the Nordic countries, and indeed they've moved on to abdominal surgery or other types of big surgery, etc., using the same thing. In the UK, we're not good at that. We can't do that because we're still stuck in blame, both in the regulatory arena and in the liability arena. So we've been working with the Department of Health trying to shift that. It's a very important point. The other reason why no blame is important is that the legal triggers have evolved. 40 or 50 years ago, or going back 100 years, the legal advance was talking about negligence or fraud, and liability was never on at all. And that's based on fault or blame. Nowadays, within, for example, the brain damage baby scenario, you don't have to ask questions in order to trigger money coming out of the bottom. You don't have to ask lots of questions about who did what and get an expert opinion about what was blameworthy or not. You can actually ask various fairly straightforward factual medical questions, which are to do with which symptoms appear, how quickly, or over what time. Look at temperature, various other readings. In other words, you apply a factual matrix within which a medical expert can say, in these circumstances, it was probably a genetic factor that could have been avoided. In these circumstances, it was just bad luck, and the medical People did the best they could, but it didn't work. It just went wrong. And in these circumstances, actually, medical practice was not as good as it ought to have been. Now, that's actually a movable issue. Avoid and simplify the decision being a judge saying that's fault, which is a very expensive and lengthy process. You simply make it into a factual list of questions that the medics agree. So it's quicker and it's much cheaper. And that's how all these schemes are evolving. So the law needs to catch up with medical advances, basically. And that's what some of these schemes do. That's that book, and they're all there. And some of you might have helped to contribute. So thank you for that. Question?
May I ask you a question or make a comment? Because I've been a criminal law professor, so if I look at the situation, if there's, let's say, if the medics are investigating on whether they have been negligent to some or contributed to some problem, I think it's pretty clear that it's a completely different set. I mean, why would you like to contribute to this investigation if you are the person to probably be prosecuted for the problem? I mean, or if you think about the civic aviation case, it's very much the same thing. But if the police comes in, if there's an investigation, I mean, the leads are heard, of course. Yes. That's the way we do it. So basically, avoiding that thing is that you can motivate everyone to participate in solving the real issue.
Yeah, absolutely.
So criminal procedure is not a very good way of finding facts.
It's so important. So that realisation, backed up by an awful lot of behavioural psychology, was precisely one of the key factors inside the idea of let's do the right thing, let's have ethical practice. Yeah. Which we are now rolling out into a number of relations between businesses and regulators. It's a no-brainer. You've got a problem, own up. Two situations. Let me give you two examples. Who finds a cartel? I'm not aware that any public competition authority has ever found a cartel. Companies, people in companies, find cartels in themselves or their subsidiaries, usually involving a very small number of people who've done this criminal conspiracy deliberately. And it's a company that finds them, or its auditors, or internal auditors, or internal auditors. And then the company tells the competition authority. What's the reaction of the competition authority? Across Europe, the reaction is to say, you've been very bad, here's an enormous fine, unless you have to be the first one to own up. In which case you get zero fine, but you still may have a large amount of money to pay damages in a separate procedure. Now, does that incentivise people finding them and owning up? No, it incentivises being the first. So there's then a game about saying, at what point do we own up or not own up? And at that point, you may get involved in some economic type cost-benefit analysis. Different situation. Whereas if you're not the first, you might get 50% off, except that everyone else is involved in the cartel. That's going to hundreds of millions. Different situation. I can now tell you large numbers of UK regulators where you go to them and say, we've got a problem, we found a problem, we think we might have done something wrong, we want to try and fix it. What do we do in these circumstances? Give us advice, and they say, sure, let's work it out. Utterly different situation. They don't start framing up with 5 years of retaliation, imprisonment, etc. It's okay, let's fix it, because you're trying to do the right thing, you've owned up, we'll sort it. Those are two different extremes. And one is frankly old-fashioned, based on deterrence theories and blame, and one is much more modern, out of which people learn and solve problems. Now, I'm not a geneticist, but my amateur reading of psychology and genetic evolution seems to be what has been by Edward Wilson, who's a very distinguished American biological anthropologist and evolutionary scientist, that basically says we have two genes and they're in competition. The old-fashioned gene, which is the blaming one, is the defensive gene, and that's an animal gene that goes back billions of years. So if we're threatened, our reactions are fight or flight. And in those circumstances, when you're threatened, you lash out, you defend yourself, you fight, you blame. The more recent gene is, so they say, about 80,000 years old, which is nothing. And that is a collaborative gene, which was produced in Homo sapiens by accident as a result of genetic mutation. And it shows us the ability to, unlike most animals, to distinguish between good and bad. So if you like, it's a moral gene. Now, when you do that, you can work out, we can hunt together. Because you work out, can we trust this person? Can we hunt together? Can we work together? Can we start dividing different tasks amongst ourselves? So you see that we learned that result very quickly, and it's a trust mechanism, because you wouldn't have trust based on good and bad and based on evidence. And then you can have lots of collaboration. Now, we've forgotten a lot of that in a regulatory system, which is as soon as anything major happens, like a gas explosion or banks ripping people off or whatever, one kicks in with the old-fashioned gene, which is who we're going to blame. But if you do that, you don't learn, you impede, as you said, sharing information. So that's where I perhaps that's wrong scientifically, but it seems to make sense that these two approaches are actually in conflict at the moment. And what one sees is that the organisations and the regulatory relationships that do this more modern approach are the ones that learn and succeed economically. And it's a question about markets, and in fact, Francis Fukuyama wrote a book about that called Trust, quite a few years ago, comparing different markets around the world, saying the ones that are in this space are the other countries that are doing well economically. Right, we now move on to, if you like, the sort of almost a grand finale, which is we've looked at the various mechanisms. And what Stefano and I set out to do a year or so ago was to say, what is the empirical evidence that these work? And where do we get to? So we looked at lots of case studies under these various 4 or 5 different mechanisms. And we said, empirically, what do they tell us?
Okay, this is the fun part. I will be very brief because I've seen that it's already 4 and I want to leave some time for important conclusions for thoughts. So what we have done is certainly we've mapped all these different techniques, we've mapped all these different tools, and then basically have asked ourselves a very simple, straightforward question is, are these tools, are these techniques being used in the different member states? Now, first of all, and again, I will not go into the details, but first of all, the question is, and that's also something that is mentioned in the report of the European Commission of last week regarding collective redress, regarding class actions. Is basically the recommendation says that all the member states should have registries, should have databases. None of the countries have that, I think, with the exception of the UK regarding group engagement order. So what we have compiled here is basically based on information that we have gathered from talking to people, many people. And I will not go into the details because that would be too difficult, but I will draw some general conclusions in a second. So this is an overview of most of these class action cases. This is a detailed one, and I will use that example. That's a detailed one of Belgium. We have since 2014 a class action mechanism, a consumer class action mechanism. To date, we have 5 cases. The last decision was, I think, a couple of weeks ago, I think, in the Volkswagen case. It's not pending anymore. I think that's a decision somewhere in December. But all of these cases, most of these cases are still pending. So there's no redress for consumers. The first one is the Thomas Cook case, which was a very fun case, which was a case about a delayed plane. It was a plane that had to fly from Gran Canaria to Brussels. All the people were on the plane, but there was somebody who was driving around with these, because in Gran Canaria, I've never been there, there's no, how do you call that, the thing to walk into the plane, you have to go on the tarmac, and then you have to walk on the escalator. There was somebody who probably dragged too many sundries, and we drove with that escalator and collided with the plane. The plane was damaged, so the plane was delayed for 6 or 8 hours. And that was the first class action. The test action, a consumer association, brought class action on behalf of those 184 class members. But by the time the test action brought class action, the company, Thomas Cook Airlines, was already compensated for that. So the class action only dealt with the fees and the costs of the consumer association and the publication costs, which was a total, I think, somewhere between 50 and 20,000 euros. It was only about the cost and the fees of the consumer association, had nothing to do with the consumers. The last case was exactly the same, which was, I mentioned that already today. In Belgium, we have a lot of strikes. Unions are a very powerful institution in Belgium. They do organize quite a lot of strikes, especially regarding the railroads. We have 2 or 3 strikes a year. And at one point, the Consumer Association was quite fed up with that. And they brought a class action not to claim compensation for the duped passengers who were the victim of these strikes. Why? Because there are existing European rules that the company applied, but simply because they wanted to change the policy. They wanted to have an improvement of the existing compensation mechanism. If we dig into these cases and look at these cases, then they are being used for different purposes than compensation, or they don't offer compensation, they only deal with other aspects. This is an overview of the Dutch Collector Settlement Act cases. There are 9 now. And what you see is the case, or the Dutch Collector Settlement Act is created to offer a solution for the DES case. I'm not sure whether you are familiar with the DES. The DES was a hormone that was given in the 60s to women. The consequence was that these women gave birth to daughters that had a lot of medical and physical problems. So there was a deficiency in the hormone. But there was a lot of litigation going on in the Netherlands, also I think in the US. And in the Netherlands, at one point, the Supreme Court of the Netherlands established liability for the company that produced and sold that hormone. At that point, the company said, we have all this litigation going on, 600, 700, 800 individual cases. We're not going to litigate these 600, 700 cases. We want to resolve them in one procedure. And then they asked the Dutch Minister of Justice to create a mechanism, and that became the Dutch Collector Settlement Act. If you look at the other cases, they are all financial product cases and securities cases. Why is that? It's not because of something that happened in the Netherlands. It has something to do with what happened in the US. I told you one of my first slides gave an overview of the class action developments in the US. At one point in the US, the Supreme Court issued a decision called the Morrison decision. Morrison decision killed what are called F-cubed class actions. So F-cubed class actions are securities class actions that were brought in the US by American lawyers, but on behalf of foreign shareholders who bought foreign stock on foreign markets. So 3 times F, that's why it's called F-cubed class actions. The US Supreme Court said in the Morrison decision, no, you can't have that. These foreigners have to deal with their disputes outside of the US. You cannot use the American class action system to do that. The American lawyers were, of course, very smart, so they looked at the world map and they said, where can we go on behalf of our foreign clients? And they said, oh, that's a little country in Europe, Jews and Chiefs, but also with the Dutch Collector Settlement Act. Why don't we try that? And with the Dutch lawyers, they set up these foundations press, and they were successful. They were able to bring these cases in the Netherlands. Some controversial cases, for example, the convening case. The convening case had nothing to do with the Netherlands. In the convening case, which was a securities case, the majority of the class members were Swiss and French. And everybody said, well, the Dutch courts are going to say that we don't have jurisdiction. The Dutch courts said that they don't have jurisdiction. And the reason is, first of all, they want to become the international settlement hub for these cases. And secondly, it's interesting for the lawyers, because what was even more striking, and you can see that on that side, these collective settlements were drafted together with American lawyers. So American lawyers were on the basis of pretensions. And they said, we also want to have 1/3 of the settlement hub. And everybody in Europe said, the Dutch court is not going to prove that. The Dutch court said, no problem. So 1/3 of the money went to the US lawyers in those cases. So if you talk about intermediate costs, transaction costs, I think that's a very nice example. So, first of all, and that is important to underline, and Chris, I will finish saying, first of all, if you look at these debates in a lot of European member states on class actions and collective redress mechanisms, the goal is usually not to create an efficient and effective instrument. No, the goal, the result, is a political compromise. That I saw that in Belgium. One political party says we want to have an opt-out. The other political party says, okay, it's fine, we can have an opt-out, but we want to have the possibility to appeal the certification decision. So the outcome of these legislative processes are efficient mechanisms that don't work. That don't work in the sense that they don't offer redress or they don't offer access to justice. So they contain a lot of procedural design process, and therefore they are not being used, or they are being used for other purposes than offering consumer redress. You can see some of these procedural design process on the slide: certification hurdles, distribution of damages, etc. And it also has to do with the catch-22 situation I mentioned a while ago, and the lack of appropriate funding and finance. But the bottom line is, if you look at these cases, all of these cases, if you look at the cases in our database and you ask a very simple question, you have a consumer that has suffered damages, is redress being offered for these consumers? Then in 89% of cases, that is simply not the case. Now, if you then look at other cases, and these are a bunch of examples, but I will not go into details because I think we've almost run out of time. But these are, I mean, Chris already mentioned that slide of Ofgem, the regulator. For example, if you see at the fines, the financial penalties over the years have gone down, but voluntary redress has gone up. Also, on the European level, regulatory redress offered or incentivized by the regulator is sometimes offered by the European Commission. There was a case against Deutsche Bahn. Deutsche Bahn owns all the railroads in Germany, but other companies can rent what is called another section, it's called traction current. They can rent that from Deutsche Bahn to use for their own trains. At one point, it was the European Commission found out that Deutsche Bahn gave a discount to companies that belong to the Deutsche Bahn group. Companies that did not belong to Deutsche Bahn had to pay more. So that was a violation of competition rules. And the European Commission started an investigation, and Deutsche Bahn immediately admitted liability. And they said, you're going to give us a fine? Wait a second. We will come up with a redress plan for the companies that suffer harm. And they got a discount, I think, for 4%, as long as it was necessary to have been compensated for the damages. And in the end, the European Commission said, fine, we will give you a fine of exactly €1. The company happy, the companies that suffer damages did not have to do anything. So that's an example of a beautiful example of regulatory redress. Also, the Banca d'Italia, which is the financial regulator in Italy, can sometimes use that mechanism. They can issue what are called specifically formula offerta, which are basically orders for financial institutions, and say, well, you have to pay people back. And if you look at the data which will be in the book, then it runs into, I think, 6-7 million that they already have paid back to consumers. UK is exactly the same. Chris mentioned the Consumer Rights Act of 2015. These are some headlines of companies that pay back. And finally, I will finish with that. This is an overview of the data of the Belgian Consumer Mediation Service. And what struck me, this is the total number of cases of last year, 7,000 cases. But what struck me, more than 50% of the cases, more than 50% of the cases, a settlement was reached between the complaining consumer and the trader. In 13% of the cases, the complaint solved. Why? Because there was automatically a solution. Once the company, the trader was confronted with it, they came immediately, paid back or restituted to the consumer. So only in 37% of the cases, there was no solution and a recommendation was issued. And if you compare that data with the data of the consumer transaction cases, I think that is striking. But I think everybody has the slides, so if you have more questions regarding the data, first of all, you should buy the book. That's my recommendation. If you have other questions, you can always ask it. And then finally, some policy issues. I will give the floor to Chris.
So if you go back to the first questions, what mechanisms do this? And these are not the broader questions about them addressed. These are questions about market behaviour or general behaviour and systems. I don't know any country, but I'm very interested to talk to here, that does all of this, that does all these well. But some countries, what we found, do quite a number of them really well. And quite a lot of countries don't do any of them at all. So what actually fixes this? We have looked at these various mechanisms along the top about court action, the piggyback, regulatory, simple ADR, or consumer ombudsman in the non-law sense, and very crudely scored them based on what we talked about, between 3 rather good and 0 terrible. And it shows you at the bottom that basically regulators and consumer ombudsmen, especially if they're working together, are just better. Certainly access, cost, time, outcomes, etc. So that's our conclusion on those points. Another conclusion based on legal system architecture is picking up the point about Advocate General Van Kerkhove. You start off with the left and the right problems. You start off with public regulation and private litigation, and they're completely different worlds. Well, they're not. And even more has changed since you wrote that article, because you've got all sorts of overlaps. So the regulators on the left are now doing it to address. But it's moved certainly away from the right-hand end onto all sorts of other things. And these are fascinating. And no doubt there are more of these boxes, but several of them interrelate. And we certainly see, for example, in our research, looking at this list, as you say, actually regulated with the right powers and consumer ombudsman, in other words, specific design of ADR, are what deliver the most numbers at the moment. Now, 1 or 2 countries are thinking about, well, we don't tick every box, so what are we going to do? And they're thinking about innovation. Anyway, that's it for now. Thank you very much for listening. So we're at questions. We hope more or less. Questions? Or do we have a break?
Okay, so if there's no immediate questions.
We got one.
We have one.
Yes.
I have a question. I just have a point information about the Finnish system. We don't have any transactions, but actually we have a very flexible system of joining complaints in the courts, including the market court. And we have, for example, a carpet case of timber transactions where we have 600 claimants making basically the same kind of claim, and the handling of the case have been much put together in the court. In addition, one point about the criminal procedure, the people who have suffered damages in of criminal action can claim and do claim compensation in criminal trials as everyday practice in our district courts. And there can be a huge number of victims in environmental crime. There can be a huge number of victims whose claims are just handled in the same trials. And actually, the criminal trials are sort of the Finnish way of solving our criminal sanctions that are a very flexible system.
Thank you, that's very useful. So we learned something. I've always thought that one of the reasons why across all the Nordic countries you haven't got many class actions are that you've got very good consumer ADR systems with the complaint boards and the consumer ombudsman system. And you've got the personal injury compensation schemes. So most other countries don't have those. And therefore the people are fighting against that mechanism, whereas that evolution is actually normal here. And so the question one asks is, what do you need particular pathways for, and which ones are prioritised? The debate in the UK says, well, we need, say, a class action for this, to which I'd say, no, you don't, you need something else. If you haven't got something else, then you would have to default into the court-based system. But if you've got something else, you prioritise that, because you don't want people to go into the system which is less effective, basically. So one keeps thinking about what is the most effective way of dealing with a particular type of problem.
Thank you, Minister Tastis. I think at one point you mentioned that Nordic ADR systems, they were very good some 40 years ago, but perhaps today it's out of date. Could you give an example?
Well, it's part of the thinking is this. When one introduces consumer dispute resolution schemes, 40 years ago, the state-of-the-art model is an arbitration-like system. In other words, you would also have a panel of people making a decision, and it's a representative panel involving maybe business people, whether it's consumer people or lawyers, academics, etc. That is sort of democratic and involving, but it's also slow, and therefore it's very cost. Whereas the ombudsman model, in the non-Nordic sense, is able to enable a pyramid to work like this. And so you can have case handlers at the bottom. And I know these may exist in some systems, because there's certainly a conversation like this in Denmark next week, and people quickly. Whereas the case handlers can give advice. The case handlers can actually sort out problems and mediation very quickly. So there are quite a few schemes. The Netherlands is a very good system. Belgian Families system are arbitration based, and they've got a big panel. And the panel is a pool. Whereas if you've got a case handling system and a single ombudsman or a single decision maker, it's frankly more efficient. Why is it got to be a panel? That's my question. Because I think it slows you down. Now, it made a lot of sense 40 years ago, but do you need it? Do you need it for representative reasons? Do you need it for expert reasons? Possibly not. I suspect that in your personal injuries compensation schemes, you haven't necessarily got a panel, remember. But you could get expert advice on certain things. So it's a question of how if we looked at this again, how quickly, how efficiently, what might we redesign? Bank of Italia are just going online. They've got a portal which is about to be rolled out. And because of that, they're getting more clients. They get better known, so the numbers go. But because they've got an arbitration panel, they've got a bottleneck. And their answer to that could be to reduce the panel system to case handlers and arbitration. But they haven't done that. What they've had to do is create more and more and more panels. It's costly. And the system is not working as quickly as it could. So you just look as a system, is it the most up-to-date model?
My also on the Ministry of Justice. Well, I just have one comment on our various scope of application cross-section legislation, which is very narrow, so with consumer claims and has never been tried. Maybe it has been neutral way, I don't know, but not in court. However, in the consumer dispute board, there's a similar action possible, and that has been used once, and the consumer ombudsman did use, and if I don't remember, if I do remember correctly, but it has been used, so it's not just an empty words. However, there is pressure, slight political pressure to expand the scope of application of the legislation process. But I don't know, maybe would your view be that this is the correct way to go forward, or is it to be understood from what you said during this presentation that maybe this is not the right path?
Well, two questions to answer that question. One is, what are you trying to solve? What problem are you trying to solve by this case? And the second is the empirical observation that we looked at. Say, let's look at all the options and score them. What works? And it's no longer a question of access to justice. Frankly, that's using access to lawyers. The outputs you want to get are that big long list of information and outputs of behavioural outputs that change behaviour so things don't go wrong. You stop them more quickly and solve the problem. How does the class action already make this deliver those? It's old-fashioned. It only delivers number 8 a bit. Americans have claimed it does more, but there's not much evidence of that. And we say, based on the evidence, the empirical evidence that we've seen so far across Europe, it doesn't even be number 8 very well. But why do you need it? Now, you might need it for things, as you were saying earlier, that you haven't got an alternative for. But what are they? What types of cats are there that are not solved?
That's the first point. The second point is also, I mean, if you have that debate, I think it's important to look at these different techniques. But again, as we have given some examples, there's a connecting. I mean, it's very well possible that you could have, for example, a regulated with the possibility of doing transaction. You could have, for example, an experimenting with independence, for example, where you have ADR mechanisms, speaking of entities, where during the ADR process, there's an issue of law. And then in the case of Israel, you do not have ADR entities issuing decisions that are based on the rule of law. If there is an issue of law, then you should go to the court. But if the Netherlands in 2012, for example, they got that concrete pre-judicial questions. For example, allows under such circumstances to ask a pre-judicial question to the court. The court resolves the issue of law, and then the rest of the situation is being resolved outside. So I think if we have that debate, I think should have that, because I think it's important to look at other techniques, look at what works as the first question, and the second question is how can you create an integrated dispute resolution framework where you can have a policy where all of these different techniques have a specific purpose within a broader context. And I think that's, if you look at a lot of legislative debates in a lot of European member states, that's completely different. They just focus on one thing and have a whole political debate about that. Then something comes out of that as a political compromise, and it doesn't work. I'm not saying you should not have a debate about it. I think you should simply have a broader look at other things and try to connect. I think that's fine, and I think that's crucial. And you see some very good examples in Europe about that. Look at the Kennedy case, look at the Act on pre-judicial questions. These are symptoms of that.
So, I mean, similarly, really what we see going on is quite a lot of experimentation as between public and private. The boxes between public and private and regulatory powers or consumer ombudsman powers or other terms, etc., etc. Lots of experimentation. But how do they deliver the outcomes we want, which are in that marketplace, for example? Or what should be in that list? How do we get that? What are the mechanisms that deal with that? And quite a lot of experimentation that completely turns on its head old questions about, oh, we need to expand the injunction structure, or we need to do something with the mediation groups. Those are just irrelevant questions. The requirement is to look at the outputs that we get and work out how we get there. And it involves quite a lot of structural thinking with empirical evidence about what works. Mr. Robertson.
Thank you. First, I would like to thank all professors for extremely interesting talks. I will not give you an explanation of why we haven't had any, but so far I've been in this office for 30 days. But I do know about the weapons, the nuclear bomb. I probably would not call our system the nuclear bomb, but I do know from the talks we have had at the office that I would say that it's a very, very vulnerable modern attack, and it hasn't been used as such for now. But I will have the pleasure to continue talking with you tomorrow morning, and that's why I will not go into much more detail. But I would like to ask how you see the European level from now on, as you have showed us. Various EU countries have reacted very differently to this whole question. And do you see that the EU should have even more active role in the future, or should it take it easy, okay, and let the member countries do as they please?
Yeah, that's a very interesting question. Incidentally, I don't think, but we'll talk about it tomorrow, that your card is strong enough. So we'd be in favour of giving you more of a bomb, because we think you could do more if you had a bit more power. Anyway, this is so extraordinary when one looks at the EU. I started talking about looking at UK policy on enforcement by public authorities. There is no European policy and almost no research on public enforcement because of subsidiarity. It's okay, member states, here's a directive, up to you how you implement it, up to you what the landscape is, what the bodies are. So only the Nordics have got consumer rights, not you. They don't exist anywhere else. various other types of them than exist in other countries. In some countries, regulators are inside ministries, in some cases they aren't. The landscapes are extraordinarily varied, and no one's looked at them. Sometimes you get people in financial services who know about financial services, but they know nothing about energy or transport. And none of this has been mapped, none of it's been studied, and no one's saying, what do you do? What are your policies? How do you deal with unlawful practice? How do you deal with A, enforcement? And secondly, what are you trying to do? Are you trying to get that with such changing behavior? Those are new questions, and no one has a clue about that. So it's never been looked at, and therefore, it seems to me that the Commission absolutely has to put the brakes on and do an enormous amount of exercise in the public enforcement and say what works and what are the techniques in order to help people forward. You can't do that very quickly because you've got utterly different national landscapes, but no one knows what they are. So it's really very difficult at the moment. And when the EU comes out with specific proposals saying, we're going to do this, we're going to increase the mediation rates, we're going to increase the injection rates. Now, they almost got it right recently in relation to consumer protection. So there was a proposal to amend the consumer protection cooperation regulation. It's a coordination mechanism for consumer enforcers. But immediately now ask questions in the national landscapes about have you got a consumer regulator or not. The Netherlands, for example, had to create one very recently because it didn't have one. And they're different because quite often we're talking to different sectors like financial services or energy, where it's a very small part of what the regulator wants to do. In that regulation as it's come out is a list of powers. The Commission proposed that the relevant regulator should have a redress power. And at that point, believe me, I cheered when I saw that, because I thought that's going to work. Germany and Italy objected because the officials that were dealing with it actually didn't understand, I suspect, what was going on, and they thought it was upsetting. Again, it's quite complicated arrangements with the two enforcement and Germany and something else in Italy was misunderstood. So it hasn't come out, and I think that's not clever. What's come out instead is a much watered down version, which is saying that companies could agree, or in certain circumstances, enforcers could possibly request, but it's unclear how far they can go, request companies to agree to voluntary redress measures. Of course, better than nothing, but it's not very clear. That would have been a mechanism that actually would have solved this problem. It's still up to the member states to include redress powers, which would be your nuclear bomb, which the UK's got and Denmark has got, certainly, and one or two others got. So you could do that. Meanwhile, the Commission is saying, well, we can't proceed with the directive on class actions, so we're going to put a damages power on the back of the injunction service. Part of that's fine, like you said, but part of this is rubbish because under, say, the German enforcement system, you'd be giving a redress power to consumer associations and trade associations. That isn't clever because the empirical data that we see is that you have to give the nuclear bomb redress power to a trusted independent public official or a regulator or yourself. Only that works when you get it to, and we've got plenty of stories that are in the book where consumer associations have brought class actions. They haven't got power, but they brought class actions, and it hasn't been well controlled. Apart from that extent, but they've only done it for particular reasons, and they've got a financial interest. And that is conflict of interest, is leading to abuse and capture by American funders, American etc. So it's absolutely predictable that that's walking into the same elephant trap that the Commission swore it would not walk into 5 years ago. That's me on a soapbox standing off that, obviously, but I think it's so important that I think the Commission is actually going to get it wrong.
Okay, so I think we should be finishing the first part here. Thank you very much, speakers, and this, you have, no problem at all. We have 5 minutes technical break, and then we take the second set of speakers, and I hope everyone will return back to this hall in 5 minutes.
Että sulla on enemmän autoriteetti. Mulle, mä voin käydä sen lyhyesti läpi, että 50.
Okay, ladies and gentlemen, we will continue.
Some more water. Some more. Is this a clean one? Is this
Yes. Do you want some?
Yes, please.
Please.
Here you are.
And so I will do the chairing from here.
Yes.
And I will introduce the first speaker, Petra Hietanen-Kuhnwall. So I have understood that you're just about to finish your dissertation.
Yes.
Is that true?
Yes.
And the topic for you today is better regulation in the periphery of the legal system. So it's interesting. We don't really know what it is about, but we will learn soon.
You will learn.
And, yes, and now, so as regards the procedure, I would say that I would propose that you speak for something like 5 to 10 minutes, and then we just we see if we can take you can take a question or one or two when you have ended, and then we go to the next one. We have 4 speakers now, and I think we will then just quickly get to the second speaker after you. So, but first, please, the floor is yours.
Well, thank you very much. And I would like to come back to this question of regulation and how you feed in information, because I think that's a very interesting point, what was presented also during the presentation. So my claim is basically that it's very difficult to make adaptations in or feedback information into the legal system if you think of a political regulation. So what I'm looking at is now the system in the periphery of the legal system, and this means the system, regulation system, and court system, and then decision-making system outside the courts. The thing is, my hypothesis is that in order to have better regulation, in order to have a feedback system, information feedback system that we can learn, we need also to have a system which is more adaptive, which creates or applies rules, introduces information, creates rules, reproduces rules, so that we get like a circle thinking. And I will sketch this out for, normally you have the legislator, you have a court, and you have a decision. And of course, the courts enjoy a very high institutional trust. People trust in the courts. They enforce substantive rights, that's what they do, and provide some sort of consistency to the legal system. Their decision-making is based on legitimation, and they're transparent. What they produce are binding decisions, basically, which have a very little impact. That's what we have heard today also, I think. They mostly concern parties that are immediately involved, but they have very little effect in the end on human behavior outside the court system. They create some precedents, but they don't feed back any information or very little information into the legislation system. That goes very long. It's a democratic process. It goes very long. So what we have alternatively, which is a bit outside the center of the legal system, is that we have legislation, we have an ADR body, and we have a decision. And here we have the ADR body who the impact depends on the trust. So if we have like the Finnish ombudsman, consumer ombudsman has a very high institutional trust, so the impact is higher. Then you have kind of different ADR systems that can be adjudicative or consensual. The adjudicative provide to some extent some consistency into the system, like if
the consumer ombudsman or the decision-making process there involves the application of law, and they will provide some kind of consistency of interpretation. And the consensual, of course, seeks to promote settlement, so there's very little consistency because basically we don't know what happens there. The outcome is just often it's a recommendation, so has no binding effect on the parties. The compliance depends on the institutional trust. Some systems are public and some are private, so it depends on the ADR body. But in the end, they can also give some guidelines and how more general guidelines, that's the difference to the courts. And they can also impact on the legislation in an advisory function. So this is what makes the ADR body the difference between the ADR body and the court. But what they don't do, so here I've summarized still, they both apply the law, at least the adjudicative ADR bodies. ADR systems have a better access to justice because they are less expensive. Formality is lower, but procedural guarantees as well very often, because you have written procedures, and the extent of the impact depends on the authority. There is no direct effect on legislation. You have no refeeding into the system. It's more or less interpretation of existing law, and the impact as such is quite limited. And depends on how much the legislator or regulator takes it into account, on the activity of the body, how many guidelines they produce and how active they are, which is of course a question of costs and how much funding they get. It's also a question of institutional trust. Do the market participants trust in this body? And for instance, if you have lots of different ADR systems, I think the institutional trust for the individual system is very low. So if you have, like in Belgium, I understood that you have brought them all under one umbrella. I think the institutional trust is higher, the impact is higher. Then it depends, of course, on the publicity of the decisions and the legitimacy, how important the impact is. I have as an example the Consumer Ombudsman in Finland and the National Non-Discrimination and Equality Tribunal, but I will not go into that because I think they are both well known. What my point is now, I want to show this system outside, or the legislation, regulation outside in the periphery of the legal system, which is basically based on private governance regimes. And one can say that this is not law anymore, but basically they draw they are based on contract law and similar kind of soft law and regulation. We have, in many of these systems, we have an ADR body or some kind of decision-making body who interprets and applies the regulation. And it depends on the system if it's adjudicative or consensual. They often take decisions which are, of course, not binding, and here the decision-making effect depends very much on other questions like is it public or private, or how much other kind of social pressure can be created outside the immediate decision-making process. But in order to refeed and make the system reflective, I think that you need some more. You need to have a system internal control that gathers this information from the outside, and tries to adapt the mechanism to the root causes, as you called it. And then you have to issue some guidance and have in this system outside the legal, in the periphery of the legal system, you have the possibility to impact directly on the regulator. And this is by changing the contracts, by changing the guidelines. And this is what the system in the periphery this regulation system makes it more adaptive to changes, to it's easier to address like new developments and so on. But of course, what is unsolved is the relation to the political legislation, because they are of course integrated in this legislation. What is required is that there's a sufficient degree of concentration of participants. So you need people who participate in this kind of regulation system. There must be trust in the system. Basically, it needs to be transparent. You need to know how it happens, how the decisions are made, how it's adapted. It should be public. And there is to be some kind of other pressure that makes like compliance with this system valuable or important, or it can be pressure from the stakeholders, it can be pressure from the media, and of course there is also some kind of legitimation required. I have two examples here just to make the point, and one is the Market Practice Board, which ensures compliance with the Corporate Code of Governance, and this is the Securities Market Association who creates and adapts this kind of regulative system, and the Market Practice Board can make preventive decision, can take advice, and they will somehow adapt the regulation regularly in 1 or 2 years intervals. The code, the governance code is addressed to listed companies. Pressure comes from the transparency of the system. They need to publish, they need to report. And in Finland, it works quite well. So it's basically, there is in Finland no listed company who doesn't comply with this code, and it's on a voluntary basis. The code is based on EC on the recommendations of the European Union, and of course there's some other kind of framework legislation, but basically it's voluntary compliance in a very reflexive system that has been established through this code of governance. The second example is the Board of Business Practice, which is a private, it's from the Finnish Chamber of Commerce, and they apply an ICC code of advertising and marketing communication practice. They also issue some kind of decisions, and what the distinction is between these two examples is that the decisions that are issued by the Board of Business Practice, they are more or less confidential, so nobody actually knows, or they issue some summaries, but it's more difficult to follow what the practice is because it's confidential. But still the companies comply, or to some extent at least, with this system and with this regulation. So this was my contribution. Thank you.
Okay, thank you so much. Petra, do we have any immediate reaction? Interesting new bodies that are not that often being discussed. So thanks for opening this for us. And then the second speaker will be doctoral student Santtu Turunen, who has been very active in the field of procedural law and ADR. And the topic for you is access and due process.
Okay. So today we've been talking a lot about efficient access to rights, and my point is to bring a bit of a classical procedural point of view into the discussion about the way or the pathway that we have to get to the rights of people. So when you talk about access to justice, you usually always refer to access to substantive rights of people. And also the access to justice is evaluated in terms of access to substantive rights. So how well the procedures actually lead to people getting access to their rights. So that might be in a narrow sense from perspective of one single person, or in a broader sense in terms of changing the behavior of companies or people on the market. Can we talk about access to fair procedure, fairness, due process, procedural rights? This is not a classic discussion, but maybe we could see it, or or have a look at the issue also from that perspective. So of course, I think everybody knows what we talk about when we talk about rules of a fair procedure, principles of fair procedure. So such qualities as independence, participation, opportunity to be heard, legal access to legal aid, legal counsel, and of course, I mean, you can also talk about access to justice as a procedural feature and procedural right. Okay, so is it really? Can we say that the emphasis on access to substantive rights actually kind of endangers the due process? I mean, that my point in this is that traditionally, when you talk about access to justice, you talk about, of course, only the substantive rights, and also you combine it with alternative dispute resolution. And if you think about alternative dispute resolution in big picture, or in the broadest meaning, it includes, of course, many kinds of procedures. But if you think about the classic alternative dispute resolution, it's often combined with methods such as mediation, where the background is in other than procedural concerns or concerns of how the procedure is. It's just that, for example, in mediation, people often only focus on whether people can find a solution together, and then it's of course much focused on that rather than in which way you get to the end result. Okay, and also the justification of different kinds of dispute resolution methods is sought in other than procedural qualities. Okay, due process rights or fair procedure, they are linked with constitutional protection, basically. So it's protection against state deciding something without due guarantees of procedure and how you handle the disputes or the problems in front of a court. So that's of course the classic picture. But can we also should we also talk about the fairness of alternative dispute resolution in bigger picture, other than just court-based system? So this has been often done in terms of arbitration, which is of course something kind of between public and private dispute resolution, in terms of it being based on a contract, arbitration agreement. It's run by private entities or private arbitrators, but then on the other side, it's enforceable. The parties after the procedure can use the state enforcement procedures to enforce the award, the result, the outcome. In arbitration, you can say that there's a kind of a trade-off between the enforcement and then some due process requirements. So because you get the state enforcement, you have to guarantee some basic procedural qualities of the procedure, so that nobody is getting enforceable awards without any procedural or any basic procedural guarantees. This is of course something that is happening on a sort of a legislative level and legal level. But then you can also say that in arbitration, for example, the due process principles have been kind of institutionalized. So they not only come in action through the requirements for enforcement or set aside criteria, but also through soft law, which has adopted them, and practices which have adopted all these and rules concerning fair procedures. And it has been also, because arbitration is a bit of is an international method of dispute resolution, so they have also developed, or they can be seen as sort of a Lex Mercatoria style transnational due process regulation. Okay, so this was an excursion. It's about how these things, I mean, how procedural rights can come into the play in private dispute resolution as well, or not court-based dispute resolution. So is there anything in the future that would lead to these principles and rules and fair procedure becoming institutionalized or becoming important for the dispute resolution methods that we have? I think that there's a risk that this might not happen because of there being a sort of shift from private to macro level approach. So in that sense, that is maybe making the development less likely. Also, many forms of dispute resolution. I mean, I think that the transition is in the direction of more consensual methods of dispute resolution from this adjudicative style dispute resolution, which might shift the focus to substance more than the procedure. Also, and whereas the fairness has in the court-based or state court procedures or even in arbitration is seen as a safeguard and a basically constitutional safeguard. In more private methods of dispute resolution, it becomes more a question of product development, which is like building a procedure that people like and people will use. And if the enforcement by the states will be less important in the future, let's imagine that it goes more, the enforcement becomes less important with all these social networks that partially maybe replace the need of actual enforcement by guns and officials, then also the state involvement and sort of the due process rights become less important. But on the other hand, one has to see that, for example, in arbitration, the fairness of the procedure also is integrated into the contract of the parties. So it's been also seen that when parties agree on some sort of procedure, they also agree on the procedure that will follow. So if that means that even the privatization and shift from state-related procedures does not necessarily mean that the fairness requirements wouldn't be relevant somehow legally. So just to these were the points I was thinking to make, but to comment on the presentation earlier. So what the how the procedural rights are relevant. So we can say that, for example, if we have like Banco Italiana or some agency that has the power to, for example, control the permission of a company to operate on a market. So then we can say that it's most effective that they just tell how things should be done. But in these kinds of procedures, it's also very important to see that who gets a right to participate in the procedures where these decisions are made. So it should be also considered whether the involvement of the parties is available, whether the procedure is fair, because it's legal action, and then you can't just bypass the procedural rights of the parties. They will somehow be relevant there can be different constructions on how they are relevant, but they are somehow relevant. And even if we think about consumer claims, which were brought up, Consumer Dispute Resolution Board. So one could say that it would be better if it was even more efficient and less like a procedure, or less like arbitration, or less like a dispute resolution board. But if you think about the situation in Finland, of course, there are like some cases that can be handled on very general level. But many of the cases are like disputes concerning purchases of houses or apartments, or disputes about purchases of cars and non-conformity of cars or apartments. And these questions are often very related to evidence. And of course, when you have an entity that de facto decides how things have to go, or has the power to tell the parties to behave a certain way, be it enforceable socially or officially, or whichever way, then one has to think of whether the procedure is in a way fair. So be it based on contract, be it based on something else, one needs to give a chance for the participants to participate. And this is, of course, a problem for the efficiency. I mean, this adds the costs, but it's not irrelevant. So this is the point. Thank you.
Thank you, Santtu. Any immediate reaction? No, good. I don't want to provoke any extra comments now, because we are running a bit late. Because there were some drinks promised after the session, so I think we need to be rushing towards the drinks. And now the next speaker will be Senior Lecturer Tapani Lohi, and he will be presenting on disputes related to estate distribution. So please.
Yes, dear listeners, my topic is really quite different one. I will briefly discuss a Swedish-Finnish special procedure in estate distribution, and it is the dispatch by an estate distributor. And according to Finnish Code of Inheritance, the heirs can freely agree upon the way in which they distribute the estate of the resident. And in most cases, the distribution is also confirmed by agreement. But agreement is not always possible. So we need a procedure in which it's possible to decide the distribution in a binding way. And so if the heirs cannot agree on the estate distribution, it is dispatched by an estate distributor who is appointed by the court. And any of the heirs can freely submit an application and demand that the court appoints an estate distributor. Here you see the paragraph. And the estate distributor is usually an advocate or another lawyer who is specializing in family and inheritance law. He or she has the power to make decisions in individual cases related to the distribution, and thereby he or she decide on the outcome of the distribution. So we can say that the dispatch procedure is some kind of court of first instance in disputes over inheritance, and only first instance. So if an heir is not satisfied with the distribution, he or she can object to distribution by bringing a suit in a district court. And then we can ask, why does we have that kind of specific procedure for the estate distribution. Why has estate distributions not been left for the courts? And the reason we understand when we know the problems which encountered in old system. At the time of the order of inheritance from 1734, those disputes were decided by the courts, and disputes often became long and complicated. The courts could not determine the final distribution with a single decision, but the heirs had to turn to the court several times. And so it was necessary to create a new procedure for distribution. It was necessary to improve to access to justice for heirs. And why the estate distribution so needs more flexible procedure than other civil disputes? There are some reasons. At first, the parties do not have a single clear claim, but each of them demands that the estate should be distributed according to the law. And so the estate distribution can be and often is more complex and broader case than many other civil disputes. There are often more than 2 parties involved. There can be 3, 4, 5, 10, over 10 years in one estate. And there are often more legal decision alternatives in a estate distribution than in a typical civil dispute. If the estate is large, there are several ways of distributing it legally between the heirs. And for the heirs, it's not always most important that the distribution is legal. More important can be maybe that it's as purposeful as possible from the point of view. Yeah, and of course, because the heirs are typically laymen, it would be in many cases difficult for them to act on their own in an ordinary civil suit process. And at the end, I would say that this subject needs more research, especially it needs more research in procedural law. It would be good if this topic would also arouse more interest among researchers of procedural law in the future. It has nowadays been a topic in family and inheritance law. And it would also need more empirical research. An interesting research topic would be how effective this procedure really is from the point of view of the access to justice. The aim has been that the estate distributor would be a quicker and cheaper procedure than ordinary civil suit process. But we should need empirical research on whether this really is the case. Thank you.
Okay, thank you, Tapani. And then last but not least, we have Assistant Professor Riikka Koulu, who will be introducing a legal tech perspective on improvement of justice. Roadmap to user-friendly law.
Okay, so thank you. I'm very well aware that I am the one standing between cocktails and us, so I'll try to be as brief in my comments as possible. So I'm here to discuss yet another miracle cure for the shortcomings of our justice systems, and to suggest that perhaps there is something to be gained by looking into legal technology, especially when we think about legal technology used for the purposes of conflict management. However, it's a double-edged sword to consider something to be a miracle cure. So techno-religious people often consider that technology is something that you just add on top of existing systems, and suddenly they start working, and we see this beautiful tomorrow where access to justice is the norm and there are no exceptions. Whereas the technophobes are really afraid that increasing the use of technology in dispute resolution would be the end of justice. It is easy to see the lure behind these techno-religious perspectives, because especially automation is very cost effective, and too often when we're talking about improving access to justice, we're also talking about money. However, I think the situation is more complex than that, and technology deserves a different approach. So instead of saying that technology is always this or that, that leads us astray. So we should approach these things with a holistic approach, while at the same time complementing that with contextual analysis. This means that in addition to discussing themes like automation as overarching concepts, we should also look into specific contexts where we try to implement technology. Legal tech at the moment it's a bit of a bubble. So the market is booming, and there is relatively little regulation at the moment. And the regulation that there is addresses certain areas, but still a lot of the field still remains at the outskirts of conflict management as we understand it. Also, the danger with bubbles is that when there's a bubble, your options are pretty much to write the bubble or say that there's nothing. And the sorry thing with technology, and especially with dispute resolution technology, is that it doesn't always work. So we need to take the lessons we learned from online dispute resolution seriously, because there's a lack of historicity when we talk about dispute resolution technology. Like Professor Hodges already pointed out, we learned a lot from ODR regulation, both on the global level of UNCITRAL as well as on the local level of EU. We noticed that the platform is not sufficient in itself. There are no efficient enforcement mechanisms. The EU platform is basically a relay platform and nothing else. There's lack of awareness. People don't find the platforms or the ODR schemes. There's reluctance to commit both on the consumer side as well as the trader side, which is a question of lack of incentives. And on a global scale, the demise of the UNCITRAL working group on ODR demonstrated that the possibilities of sufficient monitoring on a global scale, well, that's not really possible, at least not right now. But kind of these viewpoints are really important, because the shortcomings of things we've already tried help us to understand what is the actual potential behind the hype. So one of the interesting things that technology can really do is to provide scalable collective solutions. This is a screencast from Do Not Pay, but there's a lot of different applications like Flightright, which offer some type of redress for a very low price for consumers. Flightright for flight delays, and Do Not Pay originally for contesting parking tickets. And of course, there's always been conflict management instruments for such micro disputes. But what these apps actually do is that they provide easy to use scalable models that basically run on automation. In the case of Do Not Pay, it's a simple chatbot. However, these services, which are sometimes called access services, well, whereas they do address some shortcomings of the legal market, there is the question of due process and whether these are actually as fair as we want our conflict management to be. So what I'd like to see, and what is actually being one of the side notes of this day all the time, is that I'd like to see more public schemes that take access to justice seriously, but still utilize the potential inherent in legal tech. That we learn lessons also from the startup scene and from these apps, and not just from what has failed with earlier attempts with technology. I don't want conflict management, especially online, to become just a question of internal complaint management systems located within companies, but I want it to be a question of due process as well. And that basically, why do I say this? Because there is always an ethical component when we are talking about technology. This is an example of a case dealing with courtroom technology application called North Point Compass in the US courts, which is used to decide the risk of renewal of a defendant in a criminal case, which then affects the length of the sentencing. This is a piece of proprietary code. So one of the defendants who was sentenced with the help of this piece of application contested the use of this and said that it's against his due process rights and he should see the lines of code. There was a discussion in the Supreme Court of Wisconsin, who then declared that there is no due process violation because there's always the judge who evaluates the value of the percentage that the software gives them. So there's the judge, and he or she or they decide whether they should trust the app or not, without ever knowing how the app actually works. So this has tremendous implications on due process, and things can sometimes go horribly wrong. So that's why we need research on legal technology that takes conflict management perspectives into consideration and takes access to justice seriously. This is a picture of judge circles from Sweden, actually, because I couldn't find an open access photo of Finnish judge circle stones. So let's go with the Swedish ones then. Other researchers working on the interface between law and technology do not necessarily understand the access to justice perspective. And I do understand why, because when you look into copyright issues, well, the perspective of conflict management is not necessarily the first one on your mind. But this just means that the procedural perspectives add something to the discussions on digitalization. Okay, that is what we can do for legal tech, but what can legal tech do for us? Many things in my point of view. One of them is that legal tech is a clean table in a way. The discussions on dispute resolution technology or courtroom technology are distanced from the current doctrinal trenches that we face all too often. Also, these perspectives, it enables us to go beyond the traditional scope of access to justice, and it expands our view. And I give you two examples where I've noticed this to hold true. And first of them is access to legal information, which when we discuss about access to justice, we often don't consider to be that important because we are focused on the dispute resolution models. About it from a holistic perspective, we understand that access to legal information is actually the prerequisite for any dispute resolution. Because before I know I have rights or obligations, or I've done something stupid, or that somebody did something stupid to me, there will be no dispute, no conflict, nothing that needs to be resolved. And that's basically follows what you called advice and triage. And we did an empirical study on this, which I would like to highlight as well. So kind of like I would like to raise the point that there's really no access to justice without access to legal information. We need to look at it from even broader perspective than just comparing different models. Another perspective is legal design, and the very revolutionary idea that law should be easy to use, and it should be easy to use for the end users of law, which surprisingly are not the lawyers, but the lay people. Think about the implications of this idea, how it transforms the whole focus of our profession. But this is something that we should really take into consideration when we start designing systems. And what is the solution I offer here? Because there are the ethical implications, there is the potential, but there are the pitfalls. So we need to focus on this perspective of algorithmic fairness and start thinking about how could we use these scalable models to develop new types of procedures, of which some are collective of necessity. But there are two main challenges embedded in this solution I'm offering. And the first one is of regulatory scope. So we need to define the standards for algorithmic fairness, and then we need to start figuring out how to implement those standards in practice in a sustainable manner so that we don't end up repeating the old structural biases already existing in our systems or start creating new ones that weren't there to start with. That is the regulatory challenge. And the second one is a challenge of conflict management architecture. So if we are to take access to justice in this environment seriously, we need to start encompassing this idea of access to justice by design. So how can we implement these ideas of redress already at the point where we start designing these systems that start with legal information? That's all for me. Thank you.
Thank you, Riikka, and you probably noticed that Riikka Koulu is the director of our legal tech lab, and wrote her dissertation on the online dispute resolution. So now there's a final chance to comment or ask the speakers. Or do we go for drinks already? Okay, so thank you. Okay, let's go for drinks. And so thanks everyone for your contribution. Thanks all the organizers. Thanks Matti Urho for bringing our international guests here. And thanks for you for coming. So I hope that you have got maybe some new information, and that probably tomorrow you will be learned from our ombudsman. Okay, thank you.
Thank you.